I want to break down in a little bit more geeky detail the federal district court decision that said that Colt AR-15s in New Jersey are constitutional and they cannot be banned. But then the same judge, Peter Sheridan, went on to say that large capacity magazines, a political propaganda term, can be banned. Well, this decision had some good outcomes associated with it and some good findings, but overall, I would say on a good day, it's entitled to maybe a B-, C+ in terms of the quality of the work product here by the court. So we're going to break it down and discuss how this opinion by Judge Sheridan should have been written and could be improved, and I suspect will be improved considerably when the United States Court of Appeals for the Third Circuit decides this case on appeal. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and author of the brand new best-selling book, Israel Disarmed: What the 10/7 Attacks on Israel Teach Americans About the Right to Bear Arms. Check it out on Amazon if you don't already have a copy. And if you have a copy, please feel free to leave a review. By the way, I will be speaking and doing a book signing at the Gun Owners of America event in Tennessee in about 10 days. We'll do a standalone video on that and give you the details. But if you're going to be down in Tennessee at the Gun Owners of America event, well, make sure you stop on by and say hello. Okay, folks, so as you may recall from last week, the United States District Court for New Jersey, Judge Peter Sheridan, federal district court judge, said that AR-15, specifically Colt AR-15s, are in common use and cannot be banned under the New Jersey quote-unquote assault weapon ban law. But then he screwed up and said that magazines that only hold 10 rounds or anything that holds more than 10 rounds can be banned. Obviously, I would say that this was a good positive decision in terms of it actually found that AR-15s are in common use, but the quality of the work product here by the judge was not quite up to snuff in my view. We're going to explain to you exactly why, and if the judge or the law clerk's watching, hopefully this will assist him or her going forward in future Second Amendment decisions. And certainly the Third Circuit Court of Appeals, I suspect, will clean up some of this sort of faulty reasoning, sloppy reasoning. I'm sure it wasn't on purpose, but hopefully it will get cleaned up on appeal. To begin with, there's 3 cases here, and they involve several major organizations, 2 prominent ones, the Association of New Jersey Rifle and Pistol Clubs and the Firearms Policy Coalition. There was 2 major parts to this case. One was a challenge to New Jersey's law that banned AR-15s. The second was to a challenge to the quote-unquote large capacity magazine bans, which basically says that you can't have a magazine that holds more than 10 rounds. The federal district court judge said that the AR-15 ban, because they're in common use, was unconstitutional as applied to the Colt AR-15, but then went on and said that the magazine ban was constitutional. So let's dig down and get geeky about this. To begin with, let's start talking about the assault weapon ban issue, the AR-15 ban. This is where the judge, let me start with the problems and then I'll give you the pluses. The problem is that Judge Sheridan screwed up because he treated the in common use test as part of the text of the Second Amendment. This is 1,000% wrong. And if you read the Supreme Court precedent on this and or my article that explains this in great detail in the Harvard Journal of Law and Public Policy, you would understand that at a textual level of the Second Amendment, you just need to read the right of the people to keep and bear arms shall not be infringed. When you're dealing with an assault weapon ban, an AR-15 ban, the critical word is arms. The Supreme Court has defined arms textually in the Heller case. Specifically, it says that an arm is anything that can be used offensively or defensively, which obviously includes modern firearms such as AR-15s. So at the textual level, it's pretty clear that an AR-15, whether it be made by Colt or anyone else for that matter, is an arm because it can be used offensively or defensively. As a result of that, it means that a ban on them or any kind of restriction on them obviously infringes upon the right of the people to keep and bear arms shall not be infringed, because we've talked about, if you look at the founding era dictionaries of the same people, the same lexicographers, Samuel Johnson and Noah Webster, that the Supreme Court has used in the past to interpret the other aspects of the Second Amendment, if you look at those same dictionaries as to what the word infringe means, it means to hinder in some way. Obviously, if you restrict the ability to own or use an AR-15, that is obviously a hindrance of the right of the people to keep and bear arms because it's restricting the possession and the use, and therefore you have a textual infringement. Now, with that said, if you look at the Heller case, that shifts the burden to the government to do what? The government has the burden to show that there's a long-standing historical tradition of some set of laws that have been around since the time of our founding that would justify this kind of a restriction on the possession of AR-15s. And what the Supreme Court said in Heller when they struck down the handgun ban of the District of Columbia was this. They said that the only conceivable historical tradition of firearms regulation that might touch fingers with a gun ban is the notion that you cannot carry what are known as dangerous and it's conjunctive. It's both dangerous and unusual weapons. And therefore, the court created a constitutional test that says that if an arm is in common use by Americans for lawful purposes, then by definition, because it's in common use, by definition, it cannot possibly be dangerous and unusual, because if it's in common use by Americans for lawful purposes, it cannot possibly be viewed as unusual. And because handguns in Heller were ubiquitous and everyone has them, and the Supreme Court says they're obviously in common use, they cannot be banned. So too, obviously, here when you're dealing with AR-15s, of which there's 20 million plus, they're in common use and cannot be banned. But the problem is that Judge Sheraton, because he elevated the in common use test not at the historical level where the burden is on the government, he did it at the textual level where the burden is more kind of neutral. That is a mistake, because once a AR-15 is defined as an arm, which obviously it is, the burden shifts to the government. And this is critically important. And listen very carefully to what I'm about to say. There's 2 key points. Do not screw this up. Listen carefully. The first is, because the burden is on the government at the historical level of the Bruin analysis, the burden is on whom? The burden is on the government, which means what? It means that the Second Amendment plaintiffs, the Second Amendment advocates, do not have any obligation whatsoever to come forth and prove that an AR-15 or any arm for that matter is in common use. Why? Because the burden is on the government at the historical level of the text first, then history level, right? Text first, burden shifts to the historical tradition analysis part. Because the burden is on the government to do the historical analysis, and because the Supreme Court in Heller says, looking at the history at the time of the founding, dangerous and unusual is the historical test, and thus if it's in common use historically, it cannot be banned. That means, and this is key, the government bears the burden to show that a particular kind of arm, whether it be a modern semi-automatic handgun or an AR-15, the government bears the burden to show that those weapons, those arms, are not in common use. Do you hear what I just said? Very important to understand this. Because the in common use test is derived from the dangerous and unusual history of firearms regulation in America, that analysis of what is in common use or not in common use is occurring at the historical level of the text first, burden shifts to the historical analysis level. As a consequence, the burden is on the government to show that their modern day firearm is consistent with the history, and therefore the government bears the burden to show that an AR-15, which is impossible for them to do, is not in common use. You see, we don't have to show something's in common use. The government has the burden to show that something is not in common use. So that is why it's so important, and why Judge Sheraton, this is why it's important that he screwed this up and we call him out on this, is because by elevating the in common use test to the text, he basically shifted the burden to the Second Amendment plaintiffs and not to the court and not to the government, which is wrong. Beyond that, he also says that in common use is more than just ownership. This is totally false as well. Because if you look at the Heller case, when you're talking about handguns, all the Supreme Court said is people owned handguns. That's it. Owning a handgun, like owning a fire extinguisher, like owning a life insurance policy, like owning a health insurance policy, is using it. The mere possession, the mere ownership of a gun, whether you're using it lawfully for self-defense, whether you're using it lawfully in a closet in case of tyranny, whether you're using it because you want to collect them, right? Whether you're just using it because you like it on your wall as a piece of art, it doesn't matter. These are all lawful uses, and in common use simply means ownership. And yet Judge Sheridan indicated that somehow you had to show that these were used other than mere ownership. That is not what Heller says, and that's not what the concurrence by Justice Alito said in Caetano, where he just points out that 200,000 stun guns were purchased, right? He never discussed how many people used a stun gun to zap anyone, never came up. In the same way, the Heller majority never discussed how many times people pulled a trigger. It was irrelevant. Ownership alone is in common use, because owning a gun, like owning a life insurance policy or a life vest or a fire extinguisher, is using the item. Now, the other problem was it was a little bit sloppy because there's a disconnect between his rationale and his ruling. Remember, when you look at a court opinion, you have the discussion of the rationale or the reasoning behind what he's deciding or she's deciding. Then you have the actual order. Here, it's kind of weird because he talks all about how AR-15s and AR-style firearms are in common use. He talks about all ARs to show they're all in common use. And yet somehow with the remedy, he says, the way I read it, is he specifically names only the Colt AR-15 as being protected. But that doesn't make any sense, right? You literally have a finding, a whole discussion that says that all these AR-15s are in common use and cannot be banned, and yet your remedy is limited to just the Colt AR-15 and not to all the other types of AR-15s and all the other AK-47s and other semi-automatic rifles. Again, to me, this is very sloppy reasoning by someone that should know better. Judge Sheridan should know that you got to make sure that your rationale, your holding, your dicta, your reasoning all lines up and is consistent with your final order, because it's the order that the parties have to follow, not the opinion. It's the order, and here it seems like the order should have said that all AR-15 semi-automatic rifles in New Jersey are protected arms and cannot be banned because they're in common use. And yet his decision, his order is limited to Colt AR-15s. That's incongruous and doesn't make any sense at all logically. And I don't know why the court would make that decision. It makes no sense. It's illogical. Now, on the good news front, to give Judge Sheridan some compliments, he did do a pretty good job of actually finding that these arms are in common use, that the features of AR-15s make it a good firearm for civilian self-defense. That's all good, not needed, but it's good that he said it. He also, I thought, did a reasonably good job of the historical analysis in assault weapon ban cases. But at the end of the day, really, you just have to apply Heller. And I thought that Judge Sheridan did a reasonably good job of kind of getting to the conclusion that Heller already decided this, which is absolutely correct, as I've written about repeatedly and we've talked about on this channel. And there's no doubt in my mind that if the Supreme Court gets a semi-automatic rifle case, they're going to agree with exactly what I said, because I'm simply saying what the Supreme Court said in Heller and Bruin, and I'm pretty sure that I'm going to be dead on here. And here, Judge Sheridan did a reasonably good job kind of saying this, but he went all around Robinson Barn to get to what was obviously an easy conclusion just by applying Supreme Court precedent of Heller, McDonald, Bruin, Caetano, and so on. But again, he did a lot more analysis, which is fine. But again, I thought a lot of it was unnecessary to get to the easy outcome, which is if it's in common use, you can't ban it, period, full stop. Supreme Court says it. I don't need to do any more work beyond that. That's all you needed to say. All right, so this next part dealing with magazines is where Judge Sheridan totally goes off the rails. Okay. On the good news front, he starts off saying that magazines are arms, as in the right of the people to keep their arms, and that magazines are arms, so textually a restriction on them is an infringement. So he then gets that part right, so that's good news, pat on the back for Judge Sheridan. Then, of course, the burden shifts to the government, and this is where it goes off the rails. Next thing you know, rather than applying the in common use test, right, which he just analyzed for arms in the form of AR-15s, he then, for some reason, decides that the in common use test doesn't apply to magazines, even though he says magazines are arms like AR-15s. So now he's totally going off the rails, totally wrong, 150% wrong. I don't know what's going on. So then, to make things even worse, he then goes on to say that he thinks that these magazines constitute unprecedented technological changes, using that language from Bruin, which I've repudiated repeatedly in the Harvard Journal of Law and Public Policy. I'll put a link to it down below so you can see exactly the detailed reasons why. And he goes on to say because it's an unprecedented technological change, he basically doesn't have to make these in common use findings. This is 1,000% wrong. Here's why. Let me give you why, the easiest way it's wrong. In 2008, the U.S. Supreme Court decided Heller. It gave rise to the in common use test. And remember, if something's in common use, it cannot be banned. There may be other ways, by the way, that we can win a gun ban case other than in common use. But again, if it's in common use, it cannot be banned. Period, full stop. It's very easy. Now, that was 2008. What happened in 2007, folks? What happened in 2007? If you've been watching this channel, you know what I'm going to say. In the year of our Lord 2007, in Virginia Tech, you had a terrible mass shooting by a student that killed dozens of people and shot dozens of people using a modern semi-automatic handgun with quote-unquote large capacity magazines. Okay? That was in 2007. That was litigated in the Heller case. Literally in the Heller briefing to the U.S. Supreme Court, they discussed in detail the problems with magazines and modern firearms and semi-automatic handguns. They discussed the Virginia Tech shooting literally in the Heller case. Despite all that, the Supreme Court does the text, burden shifting, historical analysis thing, comes up with the in common use test, and applies it. Now, why is that important? Here you have Judge Sheridan, in the year of our Lord 2024, is calling magazines involved with mass shootings unprecedented. Now, that obviously makes no sense. Because something that's unprecedented is something that, for example, the Supreme Court has never considered before, never thought about. But that's not the case here, because as I just pointed out to you, the Virginia Tech shooting occurs in 2007. The Heller decision by the U.S. Supreme Court is decided in 2008. They consider specifically the events of Virginia Tech, which dealt with modern semi-automatic handguns and magazines that held more than 10 rounds. And the Supreme Court, despite all that, decided the in common use test was the standard, the constitutional standard to apply when you're dealing with an arms ban case. So here in 2024, you cannot logically say that magazines that hold more than 10 rounds that are involved with mass shootings are an unprecedented technological or an unprecedented social change in 2024, when in 2008, it was litigated by the U.S. Supreme Court in the Heller case, events that involved exactly those scenarios of magazines, semi-automatic firearms in 2007. By definition, in 2024, it's not unprecedented if the Supreme Court has already looked at the case and decided in 2008. Unprecedented means it's never occurred in the past. It's new, novel. It's not possibly the case if you've already decided in 2008 in the Supreme Court events involving 2007 and you're in 2024. It's simply temporal. Hello? So the fact that Judge Sheridan calls mass shootings involving these magazines unprecedented is moronic. It means you did not understand the facts of Heller and the discussion of Virginia Tech in the Heller case. Then make things even worse, that let us then go on. He says, well, now I get to engage in a looser form of analogical reasoning. Then he cites to what we've talked about on this channel before. Remember, on this channel, I will make you smarter than Judge Sheridan. I already have, by the way. Okay? I will make you smarter than federal judges on the Second Amendment. I'm telling you that. Here's an example. So here you have Judge Sheridan uses what? To justify the magazine ban. He cites to Bowie knife regulations. Now, you and I have talked about the Bowie knife or the Bowie knife. Those were not bans. Bowie knives were not banned. The laws, which are arguably come too late in time, but let's just set that issue aside. The regulations involving Bowie knives were restrictions on open versus concealed carry. You couldn't conceal carry Bowie knives. Had nothing to do with outright bans, which is what this magazine is. So again, you have Judge Sheridan using Bowie knife restrictions on carriage to justify a ban of magazines that hold more than 10 rounds in New Jersey. Totally wrong. But last but not least, and this is the most obvious error that we've talked about before, I want you to step back 1 second and let me give you the killer point about why magazine bans are unconstitutional. Very easy. Heller said that you cannot ban an entire class of firearms or an entire class of arms that are in common use by Americans for lawful purposes, okay? Now, in Heller, they dealt with handguns. I want you to think about this carefully. Once I make this point, you will never forget it, and you will use it always to win your cases, to win your arguments. If the state of New Jersey bans magazines that hold more than 10 rounds, that is a firearm ban. Do you hear what I just said? If a state bans magazines that hold more than 10 rounds, that is not a magazine ban. That is actually an absolute firearms ban of an entire category, class or category of a type of firearm, i.e., you are banning firearms, all firearms that are capable of firing more than 10 rounds without reloading. Do you see what I just said? If you ban magazines that hold more than 10 rounds, you have banned all firearms in a state that are capable of firing more than 10 rounds without needing to be manually reloaded. Thus, a ban on magazines is not just a ban on magazines, which in and of themselves are arms and thus illegal. It is also a ban on an entire class of firearms, i.e. firearms that hold more than 10 rounds that can be fired more than 10 times without being reloaded. Does Judge Sheridan grapple with what I just said? No, he doesn't. No, he doesn't. Which goes back to my point that there's some positive things that Judge Sheridan did, so he doesn't get an F here. And I think he tried to get it right. He just failed. Okay? So I'm not criticizing Judge Sheridan and his staff for not working in earnest to try to get this right. But the quality of the reasoning is not up to snuff in my view, in my opinion, and it's not consistent with Supreme Court precedent. And I don't think the U.S. Court of Appeals for the Third Circuit is going to agree with a lot of the logic and rationale and reasoning of Judge Sheridan in this case, but only time will tell. All right, folks, well, I hope you enjoyed getting a little geeky on this decision here out of New Jersey. We will keep you abreast as things develop. Don't forget to follow me here on this channel. Don't forget to follow me on X at 4Boxes Diner, and we will see you again soon here at the 4Boxes Diner.
Orders up. Table 2A.